want to talk about an estate planning myth that is important to dispel, because I hear a lot of people who believe that the power of attorney will allow you to still make decisions for someone after that someone has passed away. This is a rumor I hear all the time. This is a myth that I hear not infrequently, and it is 100% false. People go, what do I need a trust if I have a power of attorney? And when, my loved one passes away, I'll just use the power of attorney to transfer the home to me, or use the power of attorney to get money out of the bank account or brokerage account and things like that. And the answer is that you will be surprised and saddened to learn that that is not the case. Powers of attorney die with the individual who signs them, meaning once someone has passed away, a power of attorney is 100% completely useless. No one will accept it. They're not allowed to accept it by law. A power of attorney is good while someone's alive. It's also good while they're alive and, of course, no longer able to make decisions for themselves. That's where it's a very important document, and also one that should be done with care and not something that just be printed off the internet. A good power of attorney is one of the most important documents that I can provide to my clients, because it allows them to continue to delegate to someone essentially the management of their life when they're unable to do so for themselves. But no matter what, there's nothing that any lawyer can do about the fact that once my client has passed away, the power of attorney is completely useless. Now, if you want to allow someone to continue to access assets or maneuver with your assets after you've passed away, what you're now talking about is not a power of attorney, but instead a revocable trust, because a revocable trust does not die with the person who created it. The revocable trust you're allowed to build in this contingency. When the grantor, the creator of the trust, has passed away, here's who immediately takes over control. Immediately. You don't have to go to court to make it happen, but you cannot rely on a power of attorney. So this is how we can deal with real estate, financial accounts, and things like that without having to go to court. But we're not relying on a power of attorney. So this is why a revocable trust is not just for the wealthy. A revocable trust is really for anyone. At the very least, if you own a home, I don't care if you have really not very much money in the bank, but if you own a home, a revocable trust is really worth considering. And certainly when you have more significant assets or life insurance proceeds or brokerage accounts, retirement accounts, a revocable trust can provide a significant, not only asset protection for your heirs, not you, but for your heirs, but give them the maneuverability to access these accounts sort of immediately after my client passes away. But again, to dispel the myth, you're not relying on a power of attorney. Don't rely on a power of attorney to assist in your loved one's affairs after they've passed away. It just won't work. To talk more about estate planning and incapacity planning anywhere in the state of Florida, please give us a call. If you found this video helpful, please share it, give it a thumbs up, subscribe to the channel, trying to get good information out there to all of Florida. Thanks for watching. Appreciate it.